I was still wearing my black dress when I pressed my key into the front door of my grandmother's house, the house she had just left to me, and heard my aunt laughing from the kitchen. Not the soft, tearful kind of laugh that slips out at a funeral when someone tells a sweet memory. It was sharp and triumphant, the kind that belongs in a boardroom after a deal closes. My grandmother had been in the ground for exactly 4 hours, and whatever was happening behind that door was not grief. My name is Claire. I am 28 years old, and the attorney who had just finished reading my grandmother's will in a conference room across town was still answering texts on my phone. I had driven straight from that office to this house carrying a manila envelope that changed my entire life, wanting to share it with the only family I had left. Instead, I stood frozen on the front porch, my hand still on the key, listening. It was my uncle's voice I heard first. Deep, certain, the voice of a man who had spent 50 years being told he was the smartest person in every room he entered. He was my mother's older brother, the one who had borrowed money from my grandmother for 30 years and called it an advance on his inheritance. He was the kind of man who wore expensive watches he bought on credit and corrected servers on how to pronounce menu items. "The whole thing is invalid," he said, and I heard the slap of papers hitting the kitchen table. A woman with dementia cannot legally execute a valid will. I already spoke to my guy at the county clerk's office. We contest it on cognitive grounds, get the judge to toss it, and the estate reverts to intestate succession. My aunt's voice followed immediately. She had never liked me. She smiled at me at holidays the way people smile at toll booths just long enough to get through. And under intestate succession, she gets nothing, my aunt said. It splits between you and Patricia's estate, which means it comes to us since Patricia is gone. My mother had died 3 years earlier. Claire is a beneficiary under the will. Remove the will, remove Claire. I pressed my back against the doorframe so hard I could feel the wood grain through my dress. My grandmother had not had dementia. She had been sharp and careful and deliberate until the very morning her heart stopped. She had also, I now knew, been quietly building something for the last 12 years that no one in the family had any idea existed. I reached into the manila envelope I was still holding. The document on top was 41 pages long, notarized in 3 counties, and listed the total value of my grandmother's estate at $4.2 million and 3 commercial properties in the greater Chicago area. One of those properties was a restaurant building on West Randolph Street. My uncle had been operating his Italian restaurant out of that building for 9 years, paying rent to a property management company he had never looked up, never questioned, never traced back to the quiet 73-year-old woman who used to send him birthday cards with $20 in them. I was an estate attorney. I had been practicing probate law for 4 years. My grandmother had called me 2 years ago, asked me to meet her for coffee, and told me she needed help making sure things went where she wanted them to go after she was gone. I had drafted every page of that will myself. I knew exactly what it said. I knew exactly what they were walking into. I could have pushed the door open right then. I could have stood in the kitchen doorway and told them that the will was ironclad, that I had drafted it, that it had been reviewed by 2 independent attorneys and a capacity evaluator who had met with my grandmother on 3 separate occasions, specifically to document her mental clarity for exactly this kind of challenge. I could have said all of that. Instead, I took a slow breath, wiped my face with the back of my hand, and pushed the door open like a woman who had just buried the person she loved most in the world and needed her family. They were sitting at the kitchen table with a bottle of wine open between them and papers spread across the surface. My uncle swept everything into a folder the second he saw me. My aunt stood up with her arms already open, her face rearranging itself so fast I almost admired it. "There she is," my aunt said, wrapping her arms around me in a hug that lasted exactly as long as it needed to look sincere. "We were just talking about you. Come sit down. Sweetheart, this is such a hard day." I let her guide me to a chair. I set the manila envelope face down on the table. My uncle poured me a glass of wine without asking. "How was the reading?" he said. His voice was gentle, practiced. He had a gift for performing concern. "Confusing," I said. I let my voice sound small and tired. "There's a lot to process. I don't really understand all of it." My uncle nodded slowly. He exchanged the briefest glance with my aunt. That's why you have family, he said. You don't have to navigate this alone. We've been thinking, your aunt and I, about how to make sure everything is handled properly. Your grandmother was elderly. She was not always herself at the end. We want to make sure her real wishes are honored, not just whatever some document says. I stared at the wine glass in my hands. I had prepared for this. I had actually written notes in a legal pad at 2 in the morning the week before she died, mapping out what they might try. Because I had known this family my entire life and I had spent 4 years watching what grief and money do to people when those two things arrive at the same time. What do you mean? I asked. My uncle leaned forward with the careful patience of a man who believed he was explaining something to someone who needed things explained slowly. A will can be challenged, he said, especially when there are questions about the testator's capacity. Your grandmother was on several medications. She had good days and bad days. I loved her, but I have to be honest, some of the decisions she made in the last couple of years were not the decisions of a woman in full control of her faculties. He paused. We think the estate should be managed by someone with experience, someone the whole family trusts. If you sign a document authorizing me to act as administrator, I can make sure everything is handled fairly, that the creditors are dealt with, that the property taxes are paid. I can protect you from the legal mess. I looked at him. I thought about the building on West Randolph Street. I thought about the lease in my grandmother's files, the one with his signature on it, the one that had a clause buried on page 11 that gave the landlord the right to terminate with 30 days' notice if the tenant fell more than 60 days behind on rent. He was currently 91 days behind. The previous property management company had been sending notices to a P.O. box he never checked. He had no idea. That's so kind of you, I said. I let my voice go soft with gratitude that wasn't there. I don't know what I would do without you both. My aunt reached across the table and squeezed my hand. Her rings were cold. Over the next 3 days, they did not rush me. That was the sophisticated part. My uncle called every morning, just to check in, asking how I was sleeping, whether I needed anything from the store. My aunt sent flowers. They were building a version of me in their minds, overwhelmed, grateful, pliable, and they were patient about it, which told me they had thought this through. On the 3rd day, my uncle called and asked if he could come by the house to drop off some paperwork. Just preliminary documents, he said. Nothing to worry about, just so we have everything in order. I said yes. He arrived at 2 in the afternoon with a man I had never met who was introduced to me as a financial advisor. The man had a soft handshake and did not make eye contact when we were introduced, which told me he was not comfortable with what he had been hired to do. My uncle set a folder on the kitchen table and opened it to the first page. This is a limited power of attorney, he said. It authorizes me to manage the estate assets on your behalf during the probate period. It protects you. It means you don't have to deal with court filings and property managers and all of that. I looked at the document. It was not limited. It was a full transfer of administrative authority over every asset in the estate, including the power to liquidate property at my uncle's discretion. A real limited POA is 6 pages. This was 2 pages, printed on regular copy paper, with a line for my signature at the bottom. The financial advisor shifted in his chair. He knew. I just want to understand it, I said. Can I take a copy to look over? My uncle smiled. Of course. Take all the time you need. He did not know that I had already called the estate's lead property manager the morning after the funeral and introduced myself as the new owner of the portfolio. He did not know that I had already had the leases flagged for review, or that my assistant had pulled the delinquency report on the West Randolph property and sent it to me in a secure email. He did not know any of that because he had never once in his life considered the possibility that someone he was trying to deceive might be more prepared than he was. That evening, I drove to the West Randolph building. I parked across the street and sat in my car for a few minutes looking at the restaurant through the windows. The dinner service was running. I could see servers moving between tables, the warm light of the interior against the dark of the street outside. It was a Tuesday, and the dining room was maybe a third full. I had looked at the last 18 months of revenue reports that my grandmother had kept in a locked drawer in her office. The restaurant had been losing money steadily for 4 years. My uncle had been using an equity line of credit to fund the operations, rolling debt onto debt, betting that a turnaround was always 6 months away. He needed money urgently. That was the only reason he had moved this fast after the funeral. He had not loved my grandmother any less because of it. He had just run out of runway. I took a photo of the exterior and sent it to my assistant with a short message. Pull the full commercial lease, all addenda, and the delinquency file. I want a formal notice of default drafted and ready to serve by Friday. My assistant wrote back within 4 minutes. On it. I drove home and made dinner and went to bed early, because I had a court filing to finish in the morning, and I was not going to let any of this take up more space in my head than it deserved. Friday arrived cold and bright. I was at my office by 7:30. The notice of default had been prepared, reviewed, and signed. It was a formal legal document informing the tenant at the West Randolph property that he was 94 days delinquent on commercial rent, that the grace period previously offered by the prior management had been revoked upon change of ownership, and that payment of the full outstanding balance plus applicable late fees was due within 15 business days, or the lease would be terminated and eviction proceedings would begin. My assistant served it by hand at 11:15. She texted me a photo of the envelope taped to the restaurant's front door. My uncle called me at 11:47. I let it ring. He called again at noon. I let it ring again. He called a third time at 12:08, and I answered because I had a deposition at 1 and I needed this handled before then. "Claire," he said. His voice had changed. The warmth was gone. "I need you to explain something to me. I just received a notice from a law firm claiming to represent the owner of my building. It says I'm in default." "I saw a copy of that," I said. "I asked the property manager to run a delinquency review when I took over the portfolio. It looks like there's a significant balance outstanding." There was a pause. I could hear him breathing. "You took over the portfolio," he said. "I'm the named beneficiary and executor," I said. "I've been managing the transition this week." Another pause. "Longer this time?" "Claire, we need to talk about this in person." "I'm available Monday morning," I said. "My office, 9 o'clock. He did not come Monday morning. He came Sunday afternoon, with my aunt, and they rang the doorbell of my grandmother's house, my house, for 4 minutes straight before I opened the door. I had been expecting them. I was wearing a cardigan and had a cup of coffee in my hand, and I did not look like a woman in crisis, which I could see unsettled them immediately. My uncle walked past me into the foyer without being invited. My aunt followed. "You should have told us you were handling this yourself," my uncle said. He was trying to keep his voice level and not quite managing it. "This is a family matter. You could have come to us." "I am handling it as the executor of the estate," I said. "That's the role I was appointed to." "That will is being contested," he said. He pulled a document from inside his jacket and held it out to me. "I filed a petition this week with the probate court to challenge the will on grounds of undue influence and lack of testamentary capacity. Until the court rules, the estate is in legal limbo, and you do not have the authority to make any management decisions." I took the document. I read the first page and the last page, which is usually all you need. His attorney's name was at the bottom. I had gone to law school with his attorney. She was not a bad lawyer, but she was not a probate specialist. "I'll have my attorney respond," I said. "Your attorney," my aunt repeated. Her voice had that particular quality of someone performing disbelief for an audience. "Claire, you don't need an attorney. We're your family. We are trying to protect you." "I know," I said. They left 20 minutes later. My uncle's jaw was tight and my aunt had stopped pretending to smile. They had come expecting to find the version of me they had invented in their heads, the grieving, confused young woman who needed a guardian, and they could not figure out what to do with the version of me they were actually looking at. The probate challenge was filed, as he said. I had anticipated it. I had actually left a note in my grandmother's file 2 years ago, when we drafted the will, outlining the specific countermeasures in the event of a capacity challenge. My grandmother had sat in a chair in my office on 3 separate occasions with a licensed clinical psychologist who had documented her cognitive function in clinical language that was going to be very difficult to argue against in court. I had also, at my grandmother's request, recorded each of those sessions with her written consent, an hour of conversation in which she discussed, in her own clear and careful voice, exactly why she was leaving, what she was leaving to whom, and why she had chosen not to include the people who might eventually try to take it. I submitted those recordings to the court as exhibits. The hearing was set for a Thursday morning downtown. I arrived early and sat alone at the respondent's table with a single leather folder in front of me. My uncle and aunt arrived with their attorney, who greeted me across the courtroom with the slightly pained expression of someone who already knew they were in a difficult position. My cousin was with them, my uncle's son, who was 22 and had clearly been told this was going to be a formality. The judge was a woman in her 60s who had been on the probate bench for 11 years. She was not a patient audience for waste. My uncle's attorney presented first. She argued lack of testamentary capacity, citing my grandmother's age, her medication list, and a declaration from my uncle that described several incidents he claimed demonstrated confused thinking in her final year. She was professional and organized and doing the best she could with the material she had. Then it was my turn. I did not stand dramatically. I did not raise my voice. I simply opened my folder and asked the court's permission to enter 3 exhibits into the record. The first was the capacity evaluation, conducted by a licensed clinical psychologist, dated 14 months before my grandmother's death, documenting her cognitive function as intact and consistent across 3 separate sessions. The second was the recorded audio of my grandmother, in her own voice, explaining the reasoning behind her estate plan with the clarity and precision of a woman who knew exactly what she was doing. The judge listened to 4 minutes of the recording before she stopped it and looked at my uncle's attorney. "Counsel," the judge said, "your client's petition alleges that the decedent lacked the mental capacity to execute a valid will. The respondent has entered into evidence a contemporaneous clinical evaluation, finding intact cognition, and an audio recording of the decedent herself, articulating her testamentary intent with specificity. What is your response?" My uncle's attorney looked at the table for a moment. "Your Honor, we would need additional time to review the exhibits and potentially retain our own expert." "You filed this petition," the judge said. "You had time to prepare." She looked down at the paperwork. "I have some questions about the petitioner's standing as well." She turned to my uncle directly. "Mr. She used his name, which I will not use here. You are listed as a tenant of a commercial property that is now part of the estate you are contesting. Is that correct?" My uncle's attorney started to speak, but the judge held up one finger. "I'd like to hear from him." My uncle cleared his throat. "I have a lease on a property, yes. And you are currently in default on that lease?" My uncle looked at his attorney. His attorney looked at the table. "There is a dispute about that amount," he said. "I'm sure there is," the judge said. She returned to the documents in front of her. "Let me understand this correctly. You are petitioning this court to nullify a will that leaves everything to your niece, an action which would directly benefit you financially. You are simultaneously in default on a lease on a property that now belongs to your niece. And you are arguing that the woman who created both of those arrangements, who chose to leave her estate to her granddaughter, and who, according to this clinical evaluation, demonstrated full cognitive function while doing so lacked the capacity to make those decisions." She set the papers down. "The petition is denied," she said. "The will stands as executed. The estate passes to the named beneficiary in full." She looked at my uncle with the particular stillness of someone who has seen this kind of thing too many times to be surprised by it. "I would encourage the petitioner to direct his legal resources toward resolving his rental delinquency rather than pursuing actions that the evidentiary record does not support." My uncle sat very still. My aunt, beside him, looked at me for the first time since we'd entered the room. I looked back at her. I didn't smile. I didn't need to. The following week, my uncle came to my office alone. He sat in the chair across from my desk with his hands in his lap, and he was a different size than he had been at the probate hearing. The weight that money trouble puts on a person is particular. It makes them look slightly collapsed, like something structural has given way inside. "I need to talk to you about the restaurant," he said. "I know," I said. "The notice of default, I can't cover that balance. Not right now. The business has had a difficult couple of years and I've been carrying it on credit and I don't have the liquidity to pay what they're asking." "What I'm asking," I said. "It's my building." He looked at his hands. "What I'm asking." I let the silence sit for a moment. "Tell me something," I said. When you came to this house after her funeral and sat at her kitchen table and talked about contesting her will, did you think about what she would have thought of that? He didn't answer. She knew, you know, I said. She didn't tell you she knew, because that wasn't her way. But she knew you'd borrowed against her name twice in 2019 and hadn't told her. She knew about the second mortgage application you put her down as a reference for without asking her. She knew, and she made her decision about the estate with full knowledge of all of it. His jaw tightened. I'm not your enemy, I said. I'm also not going to pretend that what happened after her funeral was okay, or that the will challenge was some kind of misunderstanding. It wasn't. You tried to take something that wasn't yours. I opened the folder on my desk. Here is what I'm prepared to offer. I will restructure the lease. The delinquent balance will be set up on a 12-month repayment plan at no additional interest. The monthly rent going forward will be adjusted to reflect current market rate for that block, which is actually slightly lower than what you've been paying. In exchange, I need the withdrawal of any remaining legal challenges, and I need a signed acknowledgement that the estate has been properly settled. He looked at the paper. That's it? He said. That's it, I said. I'm not interested in destroying you. I'm interested in being done. He signed it. My aunt was a different matter. She never came to me directly. Instead, she went to social media, the way people do when they have run out of legitimate options. She posted a long, carefully worded statement on the family Facebook page, a platform that my grandmother had never used and that most of the people my aunt was trying to reach had no context for, describing me as a manipulative young woman who had isolated an elderly person for financial gain and exploited her. Grief to seize an inheritance that belonged to the whole family. It was read by approximately 40 people, most of whom were distant cousins who hadn't seen me since childhood and had no reason to have an opinion about any of this. 3 of them called me to ask what was going on. I told them, briefly and factually, what had happened. I told them that the will had been upheld by a probate court, that my grandmother had executed it with documented capacity, and that I was not interested in continuing the conversation beyond that. All 3 of them said some version of, I figured it was something like that, and we moved on. My aunt's post was up for 9 days before she quietly deleted it. My cousin, my uncle's son, sent me a text about 2 months later. It was brief and a little awkward, in the way that messages from people who know they've been on the wrong side of something tend to be. He said he was sorry about how things had gone. He said he hadn't fully understood what he was involved in. He said he hoped I was doing okay. I appreciated it. I told him I was doing fine. I meant it. Grief is strange. It doesn't arrive on a schedule, and it doesn't wait for you to finish handling the other things. I found myself missing my grandmother in the middle of work meetings, in the cereal aisle at the grocery store, in the car on the way home from depositions. She had been the person in my life who made me feel like the work I did mattered, like the careful and unglamorous business of making sure people's real wishes were honored was worth doing. She would have found the whole situation with the will challenge darkly funny. She would have said something precise and devastating about my uncle and then offered to make him dinner anyway, because that was who she was. I had the house repainted in the spring, the color she had always wanted for the front door. A deep, particular blue that she'd cut out of a magazine years ago and taped to the refrigerator and never gotten around to doing. I did it in April, and I stood in the driveway looking at it for a long time when it was finished. The restaurant on West Randolph is still operating. My uncle made the first 3 payments on the repayment plan on time, which I took as a sign that he was at least serious about the part of the arrangement that benefited him. The dining room was fuller the last time I drove past. Maybe things were turning around. I didn't need to know. I took over the management of the full property portfolio with a firm I vetted carefully, and I hired a property accountant to run quarterly reports that come directly to me. I am not a passive owner. My grandmother was not a passive person, and she spent 12 years building something quietly and carefully so that it could not be taken from her or from me, and I intend to honor that. There are people who will tell you that family is the most important thing, that blood is the only category that matters, that you owe loyalty to people simply because you share DNA. I have spent 4 years in probate law watching what happens to families when a person dies, and I can tell you that the relationships that survive that moment, the ones that come through intact, are not the ones built on obligation or blood alone. They are the ones built on genuine respect, on people who show up honestly when it is hard and not just when it is comfortable. My grandmother understood that. She left me everything, not because I was her only grandchild, but because I was the one who sat across from her in a coffee shop and listened when she told me what she was afraid of and took her seriously. She left me everything because I showed up. That is the whole story. If you have ever had to protect something that was yours, not just a house or money, but your name, your peace, your right to be treated like a person, then you already know that the hardest part is usually not the legal fight or the family meeting or the court date. The hardest part is the moment when you realize you have to stop waiting for people to do the right thing on their own and start making sure they don't have another option. That moment is not a failure of love. Sometimes it is the most loving thing you can do for yourself, for the person you lost, and even, in the long run, for the people who tried to take it. Don't forget to subscribe to Mending Stories. And if this meant something to you, leave a comment below. I read every single one.